Hi guys, welcome back to Nairobi Legal Insights. In today's video, we're going to be looking at probationary contracts in employment. By the end of this video, you must be in a position to understand what a probationary contract means, and we are also going to be in a position to appreciate what happens in instances where an employee is actually terminated and then the employer refuses to pay the salary that employee demands. Now, I want us to use a practical scenario so that you appreciate these concepts much better. So as you can see from your screen, imagine there's an oral agreement that has been entered into between Ouma and his employer, and in this case the employer is company X. They go ahead to agree on a monthly salary of 80,000, and along the way company X goes back on its promise of paying Ouma a monthly salary of 80,000, but instead the company pays Ouma 15,000. And obviously, as you can see already here, there's an issue of underpayment that Ouma goes ahead to raise, and the company refuses to rectify that situation, not to forget that Ouma and company X had an oral agreement. Even with the underpayment, Ouma continues serving in his role in company X, and later on the 8th of August 2020, Ouma receives a suspension letter dated 5th of August, suspending him from his duty with immediate effect. Now, according to Ouma, the suspension letter does not disclose any reason for suspension, meaning that you're going home, but we're not giving you a reason why you're going home. So in this particular instance, Ouma actually goes ahead to serve the suspension period, and when this period is over, Ouma actually comes back to work, and company X does not allow him back to work. Now, while this is happening, company X goes ahead to deny the existence of any terms of agreement between itself and Ouma, and it goes ahead to say that there was no agreement that Ouma was in fact to receive 80,000 per month. Remember, Ouma had entered into an oral agreement with this company, but now the company has denied everything. The company has actually gone ahead to suspend Ouma, and it does not want him back to work. So up to this point in time, you might wonder, what is next for Ouma? What steps can Ouma take to actually resolve this particular case? With the previous fact in mind, Ouma's case here is that he has been actually terminated from his employment, and he was never given an opportunity to be heard. And in response to this, company X says that in fact Ouma was given a reason for termination, but this reason was actually given to him orally. Now you can already tell that the company is relying on oral communication. Not to forget, even the first contract of employment was done orally. Now the company goes ahead to state that in fact for the time Ouma was working for it, Ouma was actually working on a probationary contract. Yeah, so this is the defense that the company is trying to rely on to avoid liability. Now in the next slide, I want us to unfold these facts to see how courts normally look at such an instance. When it comes to employment and oral contracts, and in this particular instance I'm referring to section 9 of the Employment Act of Kenya 2007, a contract of service for a period of 3 months or more shall be in writing, and furthermore to this, according to section 9.2, the responsibility to actually draw up a contract of service is on the employer. So with reference to the previous discussion we just had, the responsibility was upon company X to actually reduce the oral contract it had with Ouma to writing, meaning that a company cannot hire you for over 3 months. You agree on something, and then the company goes ahead to deny whatever you agreed upon, and the company never actually gave you a contract. Yet the law places the responsibility on the employer to actually draft a written contract. The oral agreement Ouma had with company X was supposed to be reduced into writing by company X within the meaning of section 9 of the Employment Act of Kenya. Please pay attention to this particular slide, because I want to show you how company X will be forced to pay Ouma the original salary of 80,000 per month, despite the fact that there was an oral contract and each party is trying to bring their own diverging story. Now, according to section 10.2 of the Employment Act of Kenya, an employee must be actually paid for the work he has done, meaning that you must be remunerated. And from the evidence on record, as far as Ouma's case is concerned, Company X failed to fulfill this obligation, meaning that the company never actually reduced the oral contract into writing, and the company didn't pay the agreed salary that was supposed to be paid from the beginning. Now, when it comes to any legal case, I mean, if you take a case as challenging the situation of the employment, maybe you're claiming that I was supposed to be paid 80,000, like Ouma's case, the burden of actually proving or disapproving an alleged term of a contract that was stipulated will be on the employer, meaning that as Ouma challenges Company X that the original salary was supposed to be 80,000, the burden is on Company X to prove that that amount was not in fact 80,000. Now, the only way you can prove is if you reduce the contract in writing. And in fact, at any point in time, it's the responsibility of the employer to keep work records, to reduce an oral contract into writing. And for this particular instance, pursuant to section 10(7) of the Act, the court will go ahead in this particular case to award Ouma a salary of 80,000 per month, for purposes of this specific claim, because you know what, the contract was for more than a period of 3 months. It was never reduced into writing, and the employer has no record to prove that because it was just an oral contract. And we said the employer still has the responsibility of reducing an oral contract into writing. In this particular instance, Ouma will get the monthly salary of 80,000, and he will be compensated for the times when he was underpaid. And also remember that this particular scenario I've used has been adapted from a case that actually happened in Kenya in the year 2013. If you want to review this case, it is the case of Obenge versus EasyMart Limited. These things happen whereby an employer is going to take advantage of his employee simply because they will claim that we spoke orally and we never actually had a contract written down. Not to forget, it is the responsibility of the employer to go ahead and reduce an employment contract into writing as far as the previous sections I've mentioned are concerned. The next point we need to address is the claim by Company X that at the time of terminating Ouma's contract, he was working on probation. Now, to address this claim, I want us to refer to Section 2 of the Employment Act of Kenya 2007 that defines what a probationary contract is. Remember, Company X is claiming that Ouma was working on probation. Now, as far as a probationary contract is concerned, this kind of a contract is not more than 12 months in terms of time, and it must be in writing, and it must actually expressly state that it is for a probationary period. Now, by just looking at this definition and from the previous facts regarding Ouma's case, his employment contract does not meet the criteria for a probationary contract, referring to what we just described. Remember, for Ouma, there was no written contract, and the period was even more than what the definition of a probationary contract provides. Now, you can already tell that the claim that Ouma was working on probation is a misplaced claim as far as Section 2 of the Employment Act of Kenya is concerned. In the next video, we're going to be looking at unfair termination of employment. And please don't forget to subscribe to Nairobi Legal Insights so that you receive notifications every single time we post a new video. Thank you.